At the Court of Appeal, I, as an observer, saw you as a pretty frequent dissenter on issues of criminal law. Did you ever think about your record in terms of Supreme Court appeals?
You're coming in to make your decision. You have to look them in the eyes and perhaps send them away for 10, 15, 20 years. That's a big deal.
I'm excited about this one. My guest is the Honourable Barbara Lea Veldhuis, who I clerked for at the Alberta Court of Appeal. Barb's seen it all. She was a Crown prosecutor, a defense lawyer, a judge at every level of court in Alberta, and after leaving the court last year, she opened up her own mediation practice. She had a lot to share: practical tips for advocates, reflections on judging and the legal system, and everything she's hoping to accomplish with her latest venture as a mediator. I sure enjoyed our chat, and I think you will too. So here it is. Welcome, Barb.
Thank you. Thank you.
It's been tough for me to wrap my head around calling you that. I called you Justice Veldhuis for so long that it's really ingrained. How does it feel to you no longer being Justice Veldhuis and asking people to call you on a first name basis?
Well, I don't mind at all because it's, I'm generally pretty informal, so it doesn't bother me. But I have noticed that counsel that come to mediation who've known me on the bench have a really difficult time with it. And so do some of the more junior counsel. But, we break the ice and people get used to it. But I'm just pretty happy to be Barb.
The legal profession we place a lot of stock in things like titles and prestige. So I can see how that would be hard for anyone who's appeared in front of you as a judge to then change their whole mindset and call you something different.
That's very true. It is. We're very traditional in the legal profession. And I think it's very difficult for people to just relax and be informal. And if people are more comfortable calling me judge or justice, I have no problem with that at all. I've had some quite senior folk come in for mediation who were not comfortable calling me by my first name. And that's fine. If they want to call me judge or justice, that's okay too. Just as long as it's polite.
I guess that's the number one thing. Okay? So for the listeners, you did, I guess, what I could call the Alberta bingo card. You were a defense lawyer, a Crown prosecutor for the provincial Crown. You were with the federal Crown, and you were a judge at every level of court in Alberta. Did they give you a prize for that?
No, I don't. I think they're still working on what that might be. But yeah, I've been truly blessed to be able to have a really broad cross-section of opportunities. It's been awesome. I've enjoyed every minute of it.
Is there any particular experience that stands out as your favorite? Are you able to say that one position was better than the other?
Well, they were all very rewarding, and I think I enjoyed them all. But I have to say, truly, hands down, my most favorite role was as advisory counsel for federal prosecutions on site at the RCMP when we did the proceeds of crime work. We did a lot of cross-border big drug investigations, and as advisory counsel at a time when charter law was developing, it was just incredible. I was in that role for about 5 or 6 years. We had an interdisciplinary group of folks that worked together. So I say cream of the crop: drug prosecutors. We had a chartered accountant. We had a tax person, municipal police officers. It was a real cross section of people that worked together. So truly that was a great experience with a rare group of people that worked extraordinarily well together. I reflect back on that as just a wonderful opportunity, but the other roles were great as well.
How about judging specifically? Which level of court, I guess, is the best? So you were provincial court judge, then you're Queen's Bench at the time, and Alberta Court of Appeal. Of the three, did you have a favorite place to judge?
Well, they were all different. It was great to start on the provincial bench because I'd been a criminal practitioner. So I felt very comfortable going into that role. In fact, my then chief didn't think I needed very much training at all. And I think I got 1 or 2 days to tag along behind someone. But that was a great experience because I felt comfortable in the courtroom. I think for me, it was less of a challenge because it was a bit repetitive given my background, but a good bench. It was good. Queen's Bench at the time, now King's Bench, was a bit challenging. We were at a real low point in terms of resources and so on, so it was quite a tough goal. The Court of Appeal was the most challenging, great cases, good group of people to work with. The student program was phenomenal, and I enjoyed that very much. So it was just such a good opportunity to have that experience on each of the courts. And I think each in their own way taught me a lot and gave me good experiences and good opportunities.
What was it about the student program that you liked at the Court of Appeal? I know you were in charge of that for a while. Tell me about that, your experience with the students.
Well, I love the student program actually. We got the best and the brightest that were applicants, and well, most of them anyway. The hiring part of it was really quite fun because I think we'd interview, I don't remember the numbers, I'm going to say maybe 50 people each year. So it was just so cool getting to interview and speak to the students and learn about their backgrounds. It was really, really difficult to make a choice. And in Alberta, I think we chose 9 students each year. So I had the good fortune to work part of my time in Edmonton and part in Calgary. So I got to know, I'd say over my time on the bench, about 100 students. And I would say 75% of them I had some opportunity to work with. And it was just great to spend time with them, learn about their experiences, answer questions, and just give mentorship. I truly enjoyed the program and enjoyed meeting the people. And I found it really motivational to interact with young, bright minds, to find, to kind of keep in touch with what was going on in the law schools and what the students aspired to do. I guess it was just a good fit for me, and I just truly enjoyed it. It was just fun. It was one of the really happy parts of the job because a lot of the stuff we deal with is difficult, complex, dark. We're dealing with problems and disputes and really quite terrible things in the criminal world. So the student program was just like a bright light, a really positive, rewarding aspect of life in the courts.
It's interesting you say the darker parts and things like that. I've had that experience, whether practicing law or clerking at the court, and feeling the weight of the issues that you're dealing with. I wonder, obviously every case matters and you're going to be fully invested in it, but as between being a trial judge, say, where you're seeing the parties in front of you and you're delivering decisions probably with someone who's affected directly by it sitting right there in the courtroom, versus the Court of Appeal, where most often it's going to be counsel there representing people and you're often talking about the law and not the facts as much. Maybe you can separate yourself from it a bit. Is there any difference in the weight that you feel making decisions in those different contexts?
I think for my personal experience, having sat in criminal court and then also in QB, sitting on some of the criminal matters, I felt like that was a lot of responsibility because you're right, the accused person is right in front of you, front and center. They're in the dock. You're coming in to make your decision and you have to look them in the eyes and perhaps send them away, for 10, 15, 20 years. That's a big deal. That's a big responsibility. I think on the Court of Appeal, even though we're reviewing decisions where a trial judge has made a significant decision, particularly in the criminal realm, it's still quite weighty, especially if you're not going to allow an appeal from an accused person. Yeah, I think it takes its toll. You have to think very carefully about what you're doing and give very sober thought to what the implications are. So yeah, I always thought it was a big responsibility for sure.
At the Court of Appeal, I, as an observer, saw you as a pretty frequent dissenter on issues of criminal law. Did you ever think about your record in terms of Supreme Court appeals? Is that something that you considered at all, whether your decisions were being appealed? And I guess the same question all the way back to your experience as a trial judge. Is that something that factors in? How often are you thinking about your record on appeal?
I honestly couldn't tell you how many of my decisions did go to the Supreme Court. I really have no idea number wise. I know quite a few, and I know that sometimes my colleagues would be frustrated with me. But I sort of reflect back to my time as advisory counsel, back as a Crown prosecutor, working with police officers on the front line. And sometimes they get quite frustrated with me because my goal was to make sure that they did their job properly and correctly. and that there were no shortcuts. And the goal always was, if you're going to do a criminal investigation, you do it right. And then it's unlikely that we're going to have a trial because the I's will be dotted and the T's will be crossed. And you'll have done a good investigation and you'll be beyond reproach. And that was always my goal. And I've always felt like I needed to take that with me onto the bench as well. And when I saw cases that I didn't think had been carried out properly and the law had not been followed, as I understood it, I thought it was important to speak out. So, yes, indeed, a number of my cases did go up to the SCC, sometimes upheld and sometimes overturned. I mean, it was a variety of outcomes. It wasn't like I always dissented and I'd be kicked out. And there were things that were upheld that were important issues. So I didn't keep track. I didn't care. I just felt like for each case, I gave it my best and did what I thought was the right thing.
Well, and I think you finished with a win. I haven't confirmed this since earlier this year when the Supreme Court decided Bajkovic, but because you retired when you did last spring, May, is that right?
Yeah, May 1st of 2023.
So you retired from the court, and then the Supreme Court had this weird issue with Bajkovic where they reheard it, which
Right.
was interesting and doesn't happen all that often. But you had dissented in that case, and the majority ended up siding with you when the decision was finally released. So I think it's nearly impossible at this point that the Supreme Court is hearing another case where you dissented after Bajkovic. So you're going out on a high note. That's going to go down as a truly remarkable decision in Canadian privacy and Section 8 search and seizure law. It was groundbreaking. So you're going out on a high note, I'd say.
Well, thank you for that. And that was a really very important case, probably one of the most important cases that I felt I worked on the entire time I was on the court, put so much work into it. And I just felt it was such a critical decision. And again, it would have been easy to say, well, it's just fine if the police don't need warrants to do this, don't need warrants to do that, because it's really important that we arrest the bad guy. But for me, it was, yes, this person didn't do things as they ought to have done them and perhaps should be penalized for it. But on the other hand, I felt really strongly that privacy rights were very important and they needed to be respected by law enforcement. So I felt pleased with the end result on that for sure. A very important
Right.
case, I agree.
So you're no longer with the court and you didn't fully retire. You're now mediating. What drove that decision? I mean, I got to imagine, I've counted the years you were in public service. I got to think you're set pension wise, things would be fine. You could sail off into the sunset. So why this?
Well, I think I wasn't really quite ready to throw the towel in terms of working. I like mediation a lot. I feel I took quite a lot of training during the time that I was a judge, just on my own because I really liked it. And there was the opportunity to do judicial dispute resolution as well. So I took the opportunity to do a program based on the Harvard Mediation Project out of Toronto. I started that during my time in Queen's Bench and then did a little bit along the way until I finally got my certification. Each course that I took, I really, really enjoyed it. I found my training beneficial sometimes with my colleagues on the Court of Appeal because we sit as a panel of three. And there were times when I used those mediation tools. And it feels good. Like it feels like something that I'm good at. I hope people would say that. So I felt like I had done all that I could on the court and it was time to step back from that and that I could help people in this area get good results much more efficiently and quicker. And so I set up the practice and it's going very well. I love it.
I can attest to you being good at it. You mentioned the judicial dispute resolutions at the Court of Appeal. As an articling student clerk, I sat in on one of those with you and was able to see you in action. I thought remarkable in terms of
Thank
your
you.
ability to guide parties through and come to a compromise that really at the outset of things, I, as an observer, didn't think that particular dispute resolution was going anywhere. And in, a few hours or through over the course of the day, it did get to a compromise. So saw that firsthand. You are located in Airdrie. So for people who are not Albertans, kind of a satellite 30 minutes north of downtown Calgary. Is that about right?
Yeah, that's about right. I'd say roughly, well, Calgary's full of construction these days, but roughly on a good day, about 30 minutes north of downtown. So very accessible. My goal with the mediation, and there's lots of mediators in Alberta and lots in downtown Calgary who I'm sure can just do a spectacular job for council in the city for those that don't want to leave downtown. But my goal, because I'm a rural Albertan, grew up in northwestern Alberta, and I practiced all over the province, I've always felt that there's maybe not the same access for people in both council and parties that live outside of the major cities, Edmonton and Calgary. So my goal was to set something up so that I could offer services to rural Albertans and have council be able to come close to the city but not have to drive in downtown, contend with parking. People are very stressed when they come to mediation. They're going to see the other person up close across the table from them. They're nervous. And then to have to drive into a big city where maybe they haven't been before, find parking, and then go up to a high rise, maybe on the 20th floor. It's a lot for folks. So I thought I can offer something a little bit different that's more accessible. And it's been great. I've been able to deal with a lot of lawyers in central Alberta, a lot of farm people, ranch people that can park their big pickup trucks at my door and walk in the door, and they're grateful for that.
Are you focused on a particular kind of dispute or case, or are there any limits on what you're deciding? What sort of things are you dealing with?
I would say that the last year, as things have sort of unfolded in my mediation practice, and I don't know if this is an appropriate or the proper term, but more relational kinds of disputes. I do some family law. I've done quite a bit of estate work where we have siblings that are at odds with one another over an estate. Business disputes, not major commercial disputes, but say a group of friends have got together, set up a business, and then things haven't gone well. They've been friends for 20 years and now they're not speaking, that kind of thing. So just thought that human relationship back and forth where people need to sit down at the table and talk to one another. I think perhaps that's where my strength is. And I've done a lot of that kind of work and enjoy it and have had phenomenal results. So, and I know there's lots of other former judges and other practitioners that do a lot of the big corporate commercial stuff that, I'm not saying I couldn't do it, but they're perhaps better geared toward that. And then a lot of that falls into the arbitration field. And I tend to stick with mediation and the relationship stuff as opposed to arbitration. In my humble opinion, arbitration is just a bit too much like judging. And I'm enjoying the step back from that and trying to facilitate people making their own decisions and resolutions as opposed to me imposing something on them. So somehow it feels a bit more rewarding.
You're obviously running a business now. Scrolling through your LinkedIn, it seems like the last time I could say you were running a business was maybe 1995 as a criminal defense lawyer. There's a big gap there. How has that been? I know at the court we talked about the student program. You had the clerks, the articling students, the legal counsel. There was support there for you. You had judicial assistants. I mean, a lot of support there. And you go from that to running a business and everything that comes with it. How has that transition been?
I had no problem with the transition. In fact, it was sort of a lot of fun. There was a whole different approach to things. The one thing that I learned when I thought that I was going to leave the court and do mediation is I had a goal to get a really excellent venue. And I feel like I've achieved that. And I just by a stroke of luck tripped on premises that were set up with a number of break rooms for people to have private chats with their lawyers and a couple of decent sized boardrooms, as well as parking at the front door. It was just perfect. And I just had to do a bit of cosmetic updating. The landlords were tremendous. I just hit it at a good time. So the whole process of setting it up was really a lot of fun. And it felt good to get just what I was after, and it fell into place quite quickly. So I left the court in May, and I had my premises up and running by July. So it was a couple of months of really hard work. I had a good contractor that helped me, but I had that vision in my mind and it fell into place really well. It was like it was meant to be. So I feel really good about it. I'm here on my own. I don't have staff. I do have one person that helps with my cleaning and so on, which is a blessing, but it's good. I like the freedom. I can call my own shots. I don't have to be accountable to anyone. So it's great. I love it.
Tell me some of your advocacy tips that you would give to, I guess, young litigators mostly, but probably there's some older ones who would appreciate the advice as well.
Well, I think if I was giving tips from a judicial perspective, people appearing in front of me in court, I think being organized in your thoughts, organized in your preparation is important. Really know your case, know what you're coming in to talk to the court about, and be ready to answer questions that you might not have anticipated. Like, know your case well enough so that when a judge asks a question, you're not stumped. Be sure you know about your client so that you can answer it. I think being courteous and respectful over the past few years, I think judges talked a little bit about the lack of civility in the courts. There's been quite a change over the years. I've seen that from the time I was a young lawyer and I spent my life as a courtroom lawyer. Things that perhaps are said in court these days that I just never dreamt would come out of my mouth as a practitioner. So there's been a bit of a change there. So it would be nice for people to reflect on being a bit more courteous and civil to their opponents in the courtroom. In terms of mediation, one of the things that I've noticed, maybe, everybody relates stuff to COVID as sort of on our timeline of life, but certainly the switch to virtual hearings and virtual appearances has impacted how young lawyers in particular communicate and the difficulties that they have communicating. I pretty much insist that my mediations are in person, particularly because I do the relationship kind of stuff. I think it's very important for people to sit across the table and talk to one another. I've noticed that young lawyers in particular have some difficulty and a lot of discomfort doing that. They're just not used to it. When you do stuff virtually, there's the barrier of the screen and it's just different. And so I feel like for particularly the younger bar that are coming with their folks in person, there's a little bit of discomfort there. I try to get them to relax a bit and chat with them and so on. And for the people that bring repeat clients, we've developed a rapport and a relationship, and it's great. But I think it's just for young lawyers to get out there and have that communication. The old days of meeting at the coffee shop and talking about a file just don't happen. But that was an important time, and a lot of relationships were built, and people developed skills and tools to communicate with their opponents, and it was more collegial. So I sort of see a bit of a difference there, and I hope that we can rebuild some of that.
What do you think those sort of lawyers can be doing to address that? Like, what should they be doing? Obviously, especially if you're in certain civil litigation environments, depending on the size of your firm, you might not be getting a lot of on your feet experience. So what should people be doing to make sure they are comfortable in that setting or developing those skills?
Well, I think in-person meetings are awesome. I think pick up the phone or send an email and say, hey, can we meet for coffee and talk about this? And I think a lot of things could be resolved that should never be in chambers, don't even need to go to court. If counsel just took that few minutes, had a conversation with one another. I think what you communicate in person, one thing leads to another and the conversation grows. But if you're just emailing back and forth, it's just, one line here and one line there. So to be able to have that conversation over a coffee or a meeting somewhere, I think just simple things like that would help a lot. I don't even know if people use the telephone anymore, but I always set up a pre-mediation call just with the lawyers. I try to do it in Teams or Zoom or something like that so that we look at each other face to face like we're doing and having that conversation back and forth. At least that's a starting point. And then maybe you take the next step where you meet in person. Maybe you have a four-way meeting with your clients and counsel, that sort of thing. People just need to get out there and make that effort, not be shy about it.
I think it ties into your other comment as well, and that the courteous communication is a lot easier, or it comes more naturally when you're seeing someone face to face and talking to them. It's easy when you're getting into this war of emails or lose sight of the fact that there's a human being on the other end of what you're saying. I think the in-person communication helps that a lot.
For sure. I totally agree.
It seems like the tone of judgments has also changed, not just counsel communicating with one another, but the writing style of judgments can be quite harsh. If you have, say, a Supreme Court judgment where they're pointing at one another's reasons and making very kind of targeted comments about one another. Appeal judges in some cases are quite critical of trial judges, whereas when I was a student at the court, I think most judges were very cautious, not naming the trial judge more than necessary, being very respectful of, this might have been an error, but this person's not a dummy. It's a human being making a decision. So have you noticed that at all? Do you feel like the bench has any responsibility in upholding this courteous communication in the profession?
Oh, absolutely. The bench. I mean, they of all people ought to be being courteous to counsel and respectful in written decisions and oral decisions. And I can't say that I was perfect in doing that. And I know there were times where I probably spoke inappropriately or named folks in judgments and was harsher than I ought to have been. None of us are perfect, and there's levels of frustration that we all face. But absolutely, the bench has a role in setting a guideline or setting the stage for people to follow. I think that's very important. There should be good examples that come from the bench, and there should be courtesy and respect for those that appear in front. I mean, everybody has to contribute to fixing the lack of civility. There's no question.
Is there anything you want to share with the legal community that we haven't covered already?
There are a lot of matters, whether you bring them to me or another mediator or an arbitrator. There are many, many disputes out there that could be better resolved or more quickly resolved at a mediation table than going to court. And I think a lot of folks in the past perhaps didn't realize that opportunity existed. Maybe weren't as many mediators and arbitrators out in the community as there are right now. But that really is something that lawyers should think about. It's very readily available these days, and counsel really ought to be considering it. And there are a lot of things that could come to mediation a lot earlier in the process. It's kind of a shame to see something in litigation for 5 or 6 years, get it resolved in a day of mediation, and have folks say, why didn't we do this 2 or 3 years ago? So I think counsel have to change their way of viewing things and be courageous and take something to the mediation table. And maybe only part of the issues or some of the issues will get resolved, but at least that's something off their plate. And then they may want to go to trial or to a hearing on 1 or 2 issues. Lawyers are there to offer a service to their clients, and most folks want to get things resolved quickly. So I just say, think about bringing it to the table earlier rather than later. Maybe lawyers just need to reflect a bit more about where they are on the litigation timeline and be courageous. And maybe you don't have to go through piles of questioning. Maybe you can bite the bullet, go to the mediation table and try to get some resolution before you spend hours doing stuff that might not get the results that your clients need at the end of the day.
You sometimes get this risk aversion where, well, I don't want to, until I see everything and go through this discovery process and find out what's out there, they don't want to get in a room and resolve. Do you have any thoughts on how counsel can help nudge clients along in those situations?
Well, like I say, I think you have to be a bit courageous. I think lawyers have to say, they have to have sort of that insight to know that something should be resolved and that it's not something that you're necessarily going to, maybe you won't be unsuccessful at court, but you might not be any better off than if you took it to mediation. And I think the other important thing is to try to get some end result for your clients sooner than later. It's just that things drag on far too long. Like you say, you want to be prepared to know all of the things that might be out there. But when you go to mediation, a lot of that doesn't really matter because if people are having those conversations across the table, they're going to come to a resolution. And whether you had days of questioning at the end of it all is probably not going to be that relevant. It may in some cases, but a lot of the times it doesn't matter. And you've wasted money and time to do something that really didn't matter at the end of the day.
It's, very unnatural. I think for some lawyers, there's this risk aversion that courageousness really conflicts with. But it would be good if, I see the same thing in adopting new technologies or just moving the profession forward. I think we could all do with a bit of courage and a little bit less
Yeah.
risk aversion and being stuck in our ways. But it is kind of the natural way of the profession.
It is. And we, as I said at the beginning, we're very traditional. We've been taught that way, and it's hard to break out of those old habits. By the way, so I don't forget to do this, I want to commend you on hearsay. I think you really hit your stride with, I don't know, do you call it a newsletter? What do you call it?
That is the term. I've gotten some, I think very fitting for the legal community. I've gotten blog repeatedly, net letter, which I've only heard once, but newsletter is certainly the term
Yeah.
I'm going with.
Well, it's very informative, and I love that it's written in very plain language. And most importantly, it's sprinkled with humor. And I think we could all use a bit more of that in this profession. I think it's great. I think a lot of lawyers are talking about it, and I think you've done a real good job with it.
Well, thank you for that. I really value the plain language communication, not just for, I think we have to do a lot better job of communicating to the public the substance of decisions, and I think that's very important. My main focus, though, is on lawyers and making their lives easier. Decisions are getting so long, they're so complex, and the way they're written generally, by and large, does not make it any easier to consume. And I think as we get more and more legal information out there, it places a significant burden on lawyers to be able to consume all of that very burdensome content. So that's my goal, to make things easier for the legal community and the public to understand.
Well, I totally agree with you. I think when I, as a judge, would pick up a decision and be overwhelmed reading it, that's sort of a message that as judges, we need to do better in terms of writing in plain language and writing shorter. Because the average person, if you're writing to your audience, who is the party, not just the lawyers, they can't make head nor tail of a lot of stuff that comes. And again, it's part of that tradition of writing, using fancy language, big words, things that people don't fully understand and appreciate. I think it's important so that, the average person on the street can understand what the courts have said. Well, that was one of my goals the last couple of years at the Court of Appeal, always from when I started, actually, and I wasn't always successful, that's for sure, but to try to write in plain language so that it was as short as it could be and that people could understand it. And toward the end, I'm pretty sure, again, I didn't keep track, but I know I pumped out a lot of 1 or 2 page decisions and felt really good about it because that was all that needed to be said. And some of my colleagues were getting on board with that. So I noticed that it's a little bit better and some of the decisions are shorter and in plain language. So it's coming, it's taking time.
It's the same courage we talked about, right? It's easy to fall into a formula of this is how we've always done it and this is how it should be structured. And then you have law students reading those decisions and they think this is how it's always done. And they're lawyers, this is how it's always been done. So
Yeah.
it just takes a bit of courage to switch it up, and hopefully it sticks and becomes a pattern.
I agree.
Well, thank you so much for joining me. This is excellent to chat with you. Where can people find you if they want a fantastic mediator and a stellar facility? Do you have a website people can get in touch with you?
I do have a website. It's oneroundresolution.com. I have a map on there, a few pictures of my office premises, and I have a couple little colleagues that work here with me. My German Shepherds come to work every day on that wall behind me. They come to work with me every day, and I got kennels set up in my back of my practice, so they're great company. They don't make many demands on me, so the part is all good. I don't have to give them benefits. So yeah, it's a great setup for me. One of the pluses for folks that come in, because a lot of them are rural, is they ask if they can see the dogs. And I say, when you resolve this dispute, I'll let you meet them. And that's incentive.
That's
So
great.
almost without fail, somebody asks, oh, we've resolved it. Now can we meet the dogs? So they serve their
That's a
purpose as
perfect
well.
carrot to incentivize the resolution. I know I'd be jumping on it.
Yeah.
We'll put a link so that people can track down your website, One Round Resolution, and if they're looking for a mediator, they can get in touch.
Well, thank you very much, Dylan, for talking. Always a pleasure. And I'm glad we stay in touch. And I'm glad to see you're doing well, too. You're doing good things for the profession. Again, a little
Well,
bit outside of the norm, but that's what it takes to mix things up a little bit.
I'm very comfortable being just outside the norm.
That's a good place to be. Thank you, Dylan.
Thank you.